Thank you, Minister. I now call on Stuart McMillan to speak on behalf of the Delegated Powers and Law Reform Committee. Mr McMillan, around 7 minutes.
Thank you very much, Presiding Officer. First of all, Presiding Officer, I'd like to thank all those who have contributed to the committee's scrutiny of the bill, whether it's in writing or appearing before the committee during one of our evidence sessions. I'd also like to thank the Minister and her officials for the evidence that they have provided to the committee, and also the reply to our Stage 1 report that came in yesterday, and also to the Scottish Law Commission for proposing the bill. I'd also like to thank my fellow members of the committee for their enthusiasm and tenacity in grappling with some of the issues raised by the bill. And the Minister touched upon the latter point, which I will come on to later in my contribution, which certainly was one of those areas in particular. And finally, once again, I'd like to thank the committee officials who have been excellent with their assistance to us, and also I thank them for that. We are clear that the bill proposes important reforms which will benefit people across Scotland, and as we will be aware, one of the responsibilities of the Delegated Powers and Law Reform Committee is to scrutinise certain Scottish Law Commission bills, and these bills can often be perceived as being quite technical. I believe that the committee's scrutiny of the Trusts and Succession Scotland Bill proved to be not only interesting but also showed the importance and the relevance of the legislation to everyone living in Scotland. At the outset of the debate, it's important for the Chamber to actually consider how important both trusts and succession law actually are for our constituents. A trust is a legal device for managing assets. A person, or to use the technical term, a truster, passes assets to the trustees. Normally, this is for the benefit of individuals known as beneficiaries. Beneficiaries can include small, defined groups of individuals, or large numbers of people and organisations. Trusts are used frequently to help manage estates after a death by community-based groups and organisations such as churches and charities, and individuals for a whole raft of reasons. There was almost universal support for the proposed reforms in the bill. Stakeholders reaffirmed to the committee how important trusts actually are in Scotland. The Scottish Law Commission told us that trusts permeate Scottish society. We also heard that the reforms represent a significant improvement on existing trust law, which is over 100 years old, and consequently very difficult to use and understand, particularly for lay people who actually do become trustees. Succession law, sometimes called inheritance law, sets out who should inherit someone's money, property and possessions in the event of a death, something we all know will come to every single one of us. The fairly modest provisions in the bill in front of us were again generally welcomed by stakeholders. Notwithstanding the support we heard on the bill, the committee also heard there was room for improvement and made a number of recommendations, some of which I'm now going to touch upon. Sure.
Stephen Kerr.
I'm grateful to the convener for giving way, and I also would like to say, personally speaking, I think we all owe the committee a debt of gratitude for the work that's been done on the Stage 1 report that has been presented to Parliament. But I would like to ask the convener, Deputy Presiding Officer, why it is that the committee feels, given what he has said, why a full codification of trusts, as per my earlier intervention on the Minister in respect to the Law Society of Scotland's submission to us, why that wasn't felt by the committee to be appropriate at this time.
Stuart McMillan, and then give you the time back.
No, thank you very much. I think it's certainly committee members who are in the chamber. I'm sure I'll stand to be corrected if I'm incorrect here. But from memory, it was because of the length of time and the challenge that would actually possess, certainly for government, but also certainly for Parliament, to actually get that right. There was no shortage of will or desire for that to happen, but the length of time for that to take place would certainly delay the implementation of the bill that's actually going through Parliament. But as I said, no doubt colleagues will correct me if I'm incorrect with that. Certainly, one of the areas of one such area of the new power in the bill for a majority of the trustees was to be able to remove another trustee on certain grounds, including where the trustee is deemed incapable. This is something the Minister touched upon. Although witnesses generally supported the provision, some stakeholders told the committee that they had concerns in relation to the potential for abuse, the subjective nature of assessing incapacity, and also the burden of placing the assessment of capacity on trustees who may feel unqualified to take on that role. The committee acknowledged that there is a route for someone who has been deemed incapable to challenge the removal based on incapacity through the courts. However, it felt that this route might not be clear or obvious to a trustee in that particular situation. The committee therefore hopes to see changes to the bill which would include explicit reference to the right of a trustee deemed incapable by fellow trustees to go to court to challenge the decision. The committee considered that this might be helpful to someone who finds himself in that particular situation. We also considered the point about the future-proofing of that aspect of legislation because of the different definitions of incapacity that currently exist. The committee also was able to scrutinise the bill's potential interaction with Scotland's journey to net zero. And a particular issue raised by the committee was the question on whether wording should be included in the bill to expressly permit trustees investing trust property in the absence of any relevant provision in the trust deed to choose so-called ESG investments, that's environmental, social and governance. These are considered to be more sustainable investment choices, chosen based on their environmental, social and governance credentials, even if these might not lead to the maximum possible income for the trust. Now, one witness, Yvonne Evans, suggested that this would be, and I quote, attractive and modern approach, supporting Scotland's net zero goals through, although some witnesses consider that the power may actually already exist. The committee therefore recommended the bill be amended to explicitly allow trustees, subject to the terms of the trust deed, to choose to invest in ESG investments. And we look forward to working with the Scottish Government to make this happen, and certainly once again welcome the Minister's response in this particular regard. The committee clearly heard the views of stakeholders such as the Law Society of Scotland, who expressed concerns about the bill's default position on the personal liability of trustees for court expenses in cases where the trust property is insufficient to cover any such costs. And the Law Society also pointed out that non-recovery is a standard risk of litigation, and it was unclear why the situation should be different in litigation involving a trust compared to, for example, a company. Presiding Officer, I'd like to now cover issues not currently included in the bill. Firstly, in trusts, unlike the original draft bill from the Scottish Law Commission, the inclusion of a pension trust in its definition of a trust doesn't appear in the bill, and this concerns some stakeholders. However, the Scottish Government has confirmed that it's in talks with the UK Government to grant an order under Section 104 of the Scotland Act 1988 to apply the changes proposed in the bill to pension scheme trusts. And as colleagues in the committee will know, I highlight this Section 104 order on a regular basis because, as we had in the Before Transactions Bill and also this particular bill, there can be a delay between 12 and 18 months of getting that Section 104 order through the system. Now, I welcome the fact that both Scottish and UK governments are in discussions on this particular part of this legislation, and certainly, hopefully, that would progress sooner than the 12 to 18 months. The committee therefore recommended as a priority the timely implementation of the order to ensure commencement of the bill is not delayed and that there is no need for an undesirable dual operation of trust laws. Finally, turning to issues not covered in relation to succession law, some stakeholders considered the bill should be amended to clarify the law that does not permit an unlawful killer to be an executor in the victim's estate. If unlawful killers are appointed as executors, even if they cannot inherit under the existing law, their continued personal contact with the victim's family under the guise of winding up the estate could be considered distressing, and it would be. The committee therefore recommended the bill is amended to clarify that the law does not permit an unlawful killer to be an executor of their victim's estate. And furthermore, the committee considered that, notwithstanding the presumption of innocence, it would appear to be inappropriate for a person charged with murder or culpable homicide to act as an executor during the course of this prosecution. I think the committee spent a great deal of time on this particular matter, Presiding Officer, and I think we all want to get to the same point, and we also recognise that this is a very challenging aspect to get right. So finally, Presiding Officer, if this bill successfully proceeds through Parliament, it will help our constituents in every single part of the country. It won't fix the problems facing many people who have been stung by the McClure solicitors fiasco, but I hope it can prevent many more people from being stung in the future and also being out of pocket. So we do look forward to working with the Government in advance of Stage 2, and I do certainly commend our committee's report to the Chamber. Thank you.